Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another episode of our show. Today, we have a returning guest, Lisa Golshani. Thank you for coming back to the show.
Thank you for having me.
Lisa Golshani is an estate planning attorney. Our audience should already be familiar with her. And if you aren't, you're in for a special treat because today she's going to do a presentation for us, which is titled Top 10 Lessons from Celebrity Estate Planning Mistakes. So I'm really looking forward to sharing this with you guys. So Lisa, whenever you're ready, if you would like to share your screen, we'll get started.
Yeah, so what I'm going to share with you today is some of the lessons that we can learn from celebrities, because, you know, a lot of times I think we'll assume that celebrities have, with all their wealth and all their fame, they're going to have the best advisors, they're going to have the best planning in place, but that's not necessarily the case. Oftentimes they're just like, you know, the public, like you and I, and they're susceptible to making the same types of mistakes, and they don't necessarily always have their affairs in order. So what I want to go over is a few celebrity mistakes that we can all learn from and hopefully do better. So the most essential thing is having a plan. So Prince passed away without a plan whatsoever. He didn't even have a will. And what that did was it subjected his estate to probate court. And through probate court, the statutory scheme under, it was under Minnesota law, basically decided who his heirs would be and who would receive his estate. So right off the top, he didn't even get to pick who, the beneficiaries of his life's work were going to be. So according to the state statute, it was going to be his 6 siblings that were going to inherit his estate. And who knows if he would have even wanted them to be the ones to receive his property. So it got subjected to court, and it was a 6-year-long probate process to move assets through there. During that time, 2 of his siblings passed away, and his estate was subject to significant probate fees and taxes. So if you don't have your own plan in place, basically your estate gets subjected to probate court. And in California, we have a very cumbersome system. It takes at least 1 year to 2 years to move your assets typically through that probate court system and transfer them to your heirs at law. And the court decides who your beneficiaries will be, and it may or may not be the people that you would want. And it's very cumbersome, and basically there's attorney's fees, executors' fees, appraisal fees, all sorts of fees that accumulate. And it's a public process. So anybody can go to the courthouse and, potentially try to solicit people that are coming into an inheritance and try to take advantage of them. So as much as nobody likes to think about their own mortality, the good news is that if you do plan, you can avoid probate entirely by having a solid estate plan in place, and your family doesn't have to be subjected to this, so that you can have everything privately administered, and you can choose who your beneficiaries are. You can choose who's going to be in charge of managing your estate, and everything would be private. Whereas again, if you just have a will or you have no plan, it's all public. And if you go to www.willsforamerica.com, you can look up a lot of celebrity wills, such as, I think Onassis's will is in there. And let's see, who else? Princess Diana's will is in there. President Nixon's will is in there. So you can look up a lot of celebrity wills, whereas a trust is private in nature. So if you care about your family, rule number 1 is to have a solid plan in place. Okay.
This you used a very a key term in there. You said heirs at law. That's very important. That's a very important thing for the audience to know. If you don't decide where your asset will be going, the courts will decide where your asset will be going. So that's important right there.
Exactly. And, it may or may not be the same people that you would want. And especially now that there's a lot of non-traditional family arrangements and blended families, when you default to the statutory scheme, oftentimes it doesn't reflect what that person would have wanted. So you could accidentally cut out your spouse, you could accidentally cut out your kids if you don't have a plan in place, just because the court has to follow a prescribed manual of who will inherit if you don't decide and put that in writing. Okay. So next key rule is that you got to fund your trust. So Michael Jackson passed away and he did have a revocable living trust in place, but he had not transferred his assets into his trust. So his, humongous estate got subjected to probate, and basically it defeated the purpose of having a trust. So funding your trust refers to the process of retitling your assets into your trust and making your trust the beneficiary on things like life insurance policies and retirement plans, and coordinating that with your plan. So otherwise, basically, you have an expensive, ineffective stack of documents that aren't going to accomplish your objective. So after you create a trust, you have to fund your trust. It's like adding gas to a car and giving it fuel to drive. Otherwise, it doesn't work as it's intended to. And I used to think that this was malpractice, that a lot of plans were created like this, but I realize now that it's common practice. So you really want to work with an attorney that's going to assist you and educate you and give you the support you need to make sure that your trust does get funded. So for example, we have to retitle real property into the trust. We have to change title to bank accounts into the trust. We have to reissue stock certificates to the trust. We have to assign LLC membership interests to the trust. Depending on the asset, with some assets, we don't change ownership. Some we just change beneficiary designations, like usually for life insurance policies, we'll just name the trust as the beneficiary of the trust. But you want to make sure you don't own any assets just in your individual name without a proper beneficiary designation. So if you want it to fall under the protection of the trust, it needs to be under that umbrella. So you have to actually physically retitle assets into the trust to make it work. And also to ensure that if you become incapacitated, your successor trustee can step into your shoes and manage your affairs on your behalf, without having to go to court and without having to go, the probate court again for a conservatorship. So which is like a lifetime probate for people who become incapacitated. And if they don't own their assets in trust, then oftentimes, like let's say elderly people, they become incapacitated, then the loved ones have to go to court to set up a conservatorship in order to be able to manage their parents' affairs.
That makes sense. Before we let go of this topic, can you briefly touch upon our audience? There is a safety net, I guess I would say. It's not a solution, but the Hegstead petition,
Correct.
Can you briefly touch upon if you fund your asset but left a few things out of it, what are the options, what are the things that somebody can do to a successor trustee can do to sort of avoid probate?
Right. So one of the things we do is, first of all, execute a pour-over will. And the pour-over will is a will that basically names your living trust as the beneficiary of your estate. So it's a safety net. So if you accidentally left something out of your trust that should have been in your trust, it's like a catch-all provision that says I'm leaving my entire estate, so it pours into my trust. So that works well oftentimes with small assets. Let's say you have a $10,000 bank account and it was left in your individual name, and then we can use the small estate affidavit to transfer that into your trust. But if you have a large asset that's out of your trust, we still have to petition the court through a Hegstead petition to request that the court transfer title into the trust. But that you can still bypass an entire probate process, but it's in the discretion of the judge whether the judge is going to grant that petition or not. So really what I encourage my clients to do is make sure everything is titled properly and make sure the beneficiary designations are aligned with the plan. We don't want to rely on the pour-over will, but it is there as a safety net. But my preference is that it just be used as a formality that we never really have to execute, and that the trust is the controlling mechanism for the distribution of all the assets.
Thank you.
Okay. All right. So next we have number 3. Heath Ledger passed away in 2008, and he had created a will in 2003. And his will did not include his life partner nor their child. Again, his estate defaulted. Actually, it didn't default. It went to probate court because he only had a will, and under the will, it had named his parents and his siblings as the beneficiaries of his will. So fortunately, what ended up happening is that his parents and his sibling disclaimed their interest, and it ended up defaulting to his daughter. But that was very fortunate, because otherwise his daughter would have been completely omitted and not provided for. Neither would his life partner have been provided for. So you could accidentally fail to provide for people that are your priority. So it's very, very important to update your documents periodically. The general rule of thumb is roughly every 3 years or so, you want to revisit your plan, see if your assets have changed, if your wishes have changed, if the laws have changed that might necessitate some updates to the plan. So for example, if there's a birth, a death, a marriage, a major property acquisition, you should always check in with your attorney and see if there's any updates that should be made to the plan. So it's not a one, oftentimes people think of estate planning as something that you do once and you put on a shelf and you mark it off your to-do list, and that you can never, put it aside and never look at it again. But the reality is that unfortunately it does require maintenance in order to work and function properly. You can't just set it aside forever.
Yes, that makes sense.
All right. So next is being clear. So Robin Williams passed away, and he had actually done extensive estate planning, and he had a prenuptial agreement, and he had made provisions to provide for both his children from a prior marriage and his current wife. But he had stated in his plan that he was leaving all of his personal property to his children, but there was no specificity as to what the definition of personal property was. So his wife challenged his children's receiving all the personal property and went to court, and they ended up fighting about what the definition is. So the more specific you can be, the better. Personal property can have a very broad connotation. So oftentimes people don't necessarily think of their stocks or their LLC membership interests as personal property, but those are typically under the law defined as your personal property. So it's really, really important to get specific in defining what you mean, especially if you're anticipating issues between, in blended families, between children from a prior marriage and a new spouse and things like that. It can get very sticky. So the more you can clarify, the more you can specify, the better. All right. Number 5, Philip Seymour Hoffman. So you want to plan for taxes and have a plan in place that's going to ultimately benefit you and your loved ones. So in his case, he had a longtime partner, but they had never married. And he basically left a will, and ultimately everything did end up going to his life partner. However, she got subjected to significant estate taxes and ended up paying millions of dollars to the IRS, which could have been avoided if they were legally married. In today's world, I think there's a lot of unconventional family arrangements and structures, and that's fine, but I think people need to be educated and know what the consequences of those arrangements are. So you may not necessarily feel you need marriage from a moral perspective or a religious perspective, but you should definitely explore the legal consequences of, the pros and cons of what a marriage entails. So one of the benefits of being married is that if you and your spouse are both US citizens, you have an unlimited exemption from estate taxes when planning, when transferring property to one another. So if a husband leaves money to his wife and she's a US citizen and they're married, it could be $1 billion, no matter what it is, there's no transfer tax when one spouse passes away. Whereas if you are not legally married, then you're just subject to whatever the estate tax exemption happens to be that year.
Right.
And I think right now it's pretty high. It's at $12.7 million per person. It's never been this high in the history, but it's scheduled to fall back down to half of that in the beginning of 2026. And who knows what the future holds. It can, it's been bouncing up and down, and there's a lot of political football with the estate tax exemption. So one thing you can do to protect your loved ones is consider marriage. So I know it may not be a solution for everybody or something that everybody's going to choose, but at least it should be an educated decision that people make. And this is one of the factors to take into account is estate tax liability if you don't get married.
That makes sense.
Okay. So number 6, James Gandolfini. So James unfortunately passed away, prematurely, just like most of these people did. And he was on vacation in Italy and he passed away unexpectedly. And he had Italian property that he had left instructions to be left to his children. But apparently under Italian law, they have an automatic scheme that determines who inherits. So his kids were to receive 50% of it under Italian law. His wife was to receive a quarter of the property, and he was only allowed to allocate that remaining 25%. So it's really important for people who have assets abroad to address those assets and not assume that they're going to be covered under their US plan. So whenever I have clients that have significant assets abroad, usually we are consulting with an attorney in that country of origin or an international estate planning attorney to figure out the best way to structure that, because there can be a lot of transfer tax consequences. And a lot of other foreign countries don't recognize trust the way we do in the US. So oftentimes it's necessary to create a separate will for the property that's abroad. And a lot of times people neglect to do that. They just do their planning and assume that it's going to be covered under their US trust and will, but that's not necessarily the case. And it's something that needs to be mapped out. Okay.
That is absolutely true. And, me being from Italy, I can tell you that, trusts are not really a thing in Italy. Some people use them, but they're relatively rare. And people that die without a will, it's exactly what the state does. The state decides and allocates the property. And generally, it's exactly like that. 50 goes to the children and 50 goes to the surviving spouse. Unless, like you said, you allocate that 25%. So this is fascinating and very important to know.
Absolutely. Absolutely. And sometimes there's things you can do, ways you can structure things that will help carry out your desires in a better way or in a more tax efficient way.
Right.
Okay. So next we have Whitney Houston. And what we learned from Whitney Houston is to plan for young beneficiaries. So Whitney Houston left her estate to her daughter, and she had arranged for 10% of her estate to be distributed to her daughter when she turned 18, and the entire balance, which as you can imagine was worth multi-million dollars, outright to her daughter at age 21. So I don't know if you remember what you were like when you were 21, but I know I wasn't prepared to come into, tens of millions of dollars at that time. Right. So the better way to structure things is to leave things in trust for the benefit of the kids and appoint somebody you trust to oversee that money for their benefit and have their needs provided for, but prevent them from coming into a huge lump sum distribution at such a young age. So we want the money to be used to help them achieve their goals and help them become productive and get an education, get established, So generally speaking, we don't want children to get a lump sum inheritance before the age of 25, because we want to have them a chance to get their education, get a career established. And we don't want them to rely on the money and to have it cause them to not have motivation, work and achieve on their own. So definitely there's better ways to structure this. Typically we would do an allocation of like 25. At age 25, the beneficiary would receive something like a third, and then another third at age 30, and then the balance at 35, or some variation thereof.
Right.
And if for parents that want to be even more proactive in protecting their kids, they can establish lifetime asset protection trusts for their kids so that the kids actually never get the distribution outright, but they can actually become trustee and manage their own inheritance in trust, in a lifetime trust that gives them protection against divorce, bankruptcy, creditors, predators. So there's definitely better ways to plan, and ways where we can plan so it's more tax efficient and we can bypass estate taxes when we're passing to the next generation, so that it's not subject to estate taxes when it passes down to the grandchildren.
It's incredible, the intricacies of what you're saying. Like, I mean, and it's so important. The bigger an estate is, and you know, the more you have to, there are so many layers that you can plan. I remember hearing the quote, you know, in reference to what you said, from Warren Buffett, who said, you know, I want to leave my kids enough so they could do anything, but not enough so they won't do anything, you know, so They just sit on there. So, you know, you want to make sure they're provided for and their needs are met, like just like you said, but you probably don't want to give them so much money that they're not going to do anything with their lives because they have no incentives, just like you said it.
Exactly. And yeah, so, and as you said, in a large estate, there's a lot of intricacies, but even if you don't have a large estate, it may become more essential to preserve what you do have and make sure that it's structured properly so that it goes farther and works for your family.
Yes.
Okay.
True.
So number 8, we have Casey Kasem. And what we learned from him is to plan for our incapacity and having clarity of what our wishes are. So when he passed away, he again had children from a prior marriage who had a bitter relationship with the new wife. And he developed Lewy body dementia. And there was a lot of dueling and fighting over both conflicting healthcare directives and what his end of life wishes were. So whenever you create a new healthcare directive or a new type of document, you want to be clear to say whether it supersedes the prior document and it revokes any prior documents.
Right.
And you really want to be as clear as possible as to what your wishes are. So in this case, I guess it was not clear what he would have wanted, whether he would have wanted to have his life prolonged or not, and what kind of treatment he would have preferred to have. So this ended up in a lot of fighting, which could have simply been avoided if it was really plainly spelled out as to who's in charge of making medical decisions and what his wishes are. So the more you can provide that, you really relieve the family from the burden of having to make those decisions and fighting amongst themselves. So in general, I think setting expectations and letting people know what to expect in advance is very, very important. All right, so number 9, we have J. Howard Marshall and Anna Nicole Smith. So he was a oil tycoon, and I think what was he in his 90s or so when he married the young Anna Nicole. And they were married for 14 months before he passed away, and he had a will and she was omitted in his will. So what she did was she sued, and she was saying that she was omitted by accident. So if you don't want to provide for somebody, whether it's a spouse, a child, or any person who would inherit from you, it's very important to explicitly state that you are intentionally not providing for this beneficiary or this person. Otherwise, they can make a claim that they were unintentionally omitted, that had this person redone their will, had this person had a chance to do a new will, they would have provided for you. So this case was litigated for 20 years, and it went all the way up to the US Supreme Court. And during this time period, almost all the interested parties died, which is such a shame. So it's really important to state what your wishes are. And when your circumstances change, such as a marriage, even if you don't want to provide for your new spouse, you need to explicitly state that you're not providing for that new spouse. Otherwise, they can come back and say that, no, it was an accident, that I was omitted from the will.
Right.
Okay, so we want very clear language and a no contest clause. in the trust to help prevent people from contesting the terms of the
Can
trust.
you go a little bit into details of what is a no contest clause in a trust?
So a no contest clause in a nutshell is a provision that says that if you contest the terms of the trust and you are not victorious in your contest, then you will forfeit your share of that trust. So it's a disincentive to challenge what the person has put in place. So oftentimes when people will want to not provide for somebody, let's say they're estranged from a child and they don't want to provide for that child, oftentimes I will encourage them to at least leave that child something. So as a token, and so that they have a disincentive to challenge the terms of the trust. Because let's say you leave your kid $25,000, you're the kid that you're estranged from, and there's a no contest clause. If they contest the trust, they have the burden of proof. They have to show by a preponderance of evidence that, you know, that there was either fraud or you didn't have competence when you wrote your trust, or there was undue influence. They have a very, very high burden that they'd have to show to prove that this will or this trust is invalid. So if they can't meet that burden, they will forfeit their inheritance. So it'll make people think twice. Like if you have $25,000 is better than nothing, and it will make a lot of people think twice about challenging something if they don't have really sufficient evidence to prove that you didn't know what you were doing or that there was funny business going on. Right. So oftentimes we will include a no contest clause that discourages people from fighting and stating that you know they should be entitled to more than what they're provided for under the terms of the trust.
That makes sense.
Number 10. So this one is former Supreme Court Justice Warren Burger, and he died in 1995, and he had an estate of worth 1.8 million, which would probably be worth a lot more, you know, in today's dollars.
Of course.
And he had created his own will, and it was only 76 words, and it was full of typos. And it failed to give his executors the appropriate powers to dispose of his estate. So you want to make sure that your estate plan is drafted by an estate planning attorney that has expertise in specialized training in drafting estate plans, because if you don't do this for a living, you just don't know what you're missing or what you could be overlooking. So even in this case, we could see that a Supreme Court justice can go wrong with doing their own plan. And if you're trying to save money for your family by doing it yourself, ultimately it will usually backfire and ultimately down the line cost your family a lot more money, because it will lead to trust litigation or ambiguity that needs clarification by the court. So oftentimes people will either not execute their documents properly, or they'll put conflicting terms into their own trust agreement, or the way they word things is ambiguous and vague, and then they have to go back to court for instructions on how to proceed. So I feel like my job oftentimes is talking people out of what they had initially planned, because people have an idea and oftentimes they're not sure of what the consequences of that are or what alternatives are available to them on how to structure an inheritance. So half the time my job is telling people, no, let's not do it that way. Let's think about how about we do it this way, or what, you know, here's an alternative way of doing it, and this is why I suggest we do it this way. So you want to build a plan with flexibility. The goal is not to just have documents, but have a plan that works for your family, and for your family to have an advisor to turn to when they need somebody. God forbid, if the unthinkable happens, they have somebody who can hold their hand and walk them through the trust administration process. So if you look at a lot of those websites, those like will.com or things, they'll have disclaimers saying that we do not take responsibility for your plan working for you. So at least when you work with an attorney, you know that they are liable for the work that they're producing, and they're going to be inclined to want to have something that works for you, because they are personally responsible for the work product that they are producing. So it's important to put a plan in place and work with an expert. And don't procrastinate. That's the number one reason that people don't have a plan in place, is that they procrastinate, and it's just usually they put it off until it's too late. And when an emergency comes up, and oftentimes when an emergency comes up, it's too late to do proper planning, and then you have no choice but to go through the courts.
That makes total sense. That's great. Thank you so much. Thank you so much for sharing this. Thank you so much. This has been such a wonderful presentation. And I love what you said about, coming to your clients as an educator. Like you're telling, like sometimes you have to talk them out because they don't know. Like they're thinking, oh, we're going to do this, this, and this, and this. They're like, look, in my experience, that is why it's so important to have trusted advisors. That's why it's so important.
Yeah, because circumstances can change, and sometimes people have something in mind. So for example, somebody might say to me, my kid has to earn a university degree before they get their inheritance. I'll say, okay, but what if your child is in a, God forbid, a horrific accident and they are not able to go to university and get a degree? Or what if they join the military and they rise in the ranks and they become a general in the military, but they don't have a 4-year, university degree? Or what if they pursue the arts? So a lot of times people don't think through a lot of their, their goals. So we want to have that flexibility in place.
All right. Well, thank you so much. It's been such a pleasure to have you back, and we'll definitely make sure that, if somebody is in need of an estate planning attorney, that we share their contact information with them. It's been wonderful. Did you have any parting words for our audience?
The pleasure was mine, Matias. Thank you for having me. And just the audience, please feel free to reach out if you have any estate planning questions. I'd be happy to hear from you.
Okay, thank you very much. Bye, everybody. We'll see you on the next episode. Bye.